welcome and thank you for coming to our inaugural speaker event of the 2020-2021 academic year. My name is Greer and I'll be hosting today's speech alongside my co-chair Sean Timlick on behalf of the Distinguished Speakers Committee. We're excited to kick off yet another year of engaging speeches given by highly reputable individuals in the legal profession. We'll be hosting multiple events throughout the year, and we couldn't be happier to start off our speaker series with the highly renowned John Burroughs. We hope you enjoy the unique perspectives and insights from what is sure to be a fantastic speech. I'll now pass things over to Professor Coyle to better introduce today's speaker.
Thank you, Greer. Good afternoon, everybody. Anin. I'm delighted today to introduce Professor John Burroughs, who will be kicking off our Distinguished Speakers series this year. Professor Burroughs is Anishinaabe, a member of the Chippewas of Nawash First Nation on Georgian Bay, not that far from here. John is a Canada Research Chair in Indigenous Law at the University of Victoria. He's perhaps the most well-known scholar in Canada on Aboriginal law and Indigenous law. That is, the law actually created and applied by Indigenous peoples, not the Canadian state. John's scholarship on constitutional law, law teaching in law schools, and the relationship between Indigenous laws and the state has been incredibly influential, not just in Canada, but abroad, and in particular in New Zealand as well. John is also a prolific scholar. I count some 7 books in the last 20 years or so. So he's very prolific, and he's writing on one of the most pressing issues in Canada today, and that is what space and what respect will be accorded to Indigenous peoples in Canada, to their values, their governance decisions, and their laws. I will skip over some of Professor Burroughs' credentials. He's been a Trudeau Fellow. He's a Fellow of the Royal Society of Canada. In 2017, he won the prestigious Killam Prize in Social Science. But perhaps just to end, I want to emphasize that Professor Burroughs has been a friend both to me and to Western law over the years. I first met John perhaps 20 years ago, maybe longer, when we were both presenting to leaders of administrative tribunals. And since then, and since I have come to Western as a professor, Professor Burroughs has been very thoughtful and kind in helping me craft my own work and looking at drafts of papers when I had them and offering his own thoughtful comments. And in particular, I have happy memories of 2 or 3 years ago when Professor Burroughs and I worked together to edit a book. And that book was the project of both Indigenous scholars and non-Indigenous scholars who were asked to share their own visions of how treaties and the treaty relationship could be reimagined to better reflect the relationships created by Canada's and First Nations historical treaties. So John has been a friend of mine. He's been a friend of Western's. He's taught here. He led the teaching team at our first Indigenous Law camp, which was at the Chippewas of the Thames First Nation a little while ago. And perhaps just in closing, I mentioned to my small group yesterday that I was lucky enough to hear Lord Denning speak in London, Ontario, before coming to law school. He addressed the graduating law class, and he told us that lawyers have a responsibility to be agents of social change. Now, to me, Professor Burroughs is a paradigm example of a legal scholar who is also an agent of social change in Canada. His writings on the appropriate relationship between Indigenous peoples' values and laws and non-Indigenous values and laws, his writings, and his work on the ground in both in running camps on various First Nations territories to better propagate understandings of Indigenous laws, and even most recently, he was a driving force in creating the joint common law Indigenous law degree at the University of Victoria Law School. So we're very privileged to have Professor Burroughs speak with us today, and I'm delighted to introduce him. He's going to be talking about how Indigenous ethics are relevant to the practice of law. Miigwech. John.
Miigwech. Can you hear me? Buju Nadinaway Magani Dok, Niji Anishinaabe, Niji Marzig, Bangietago Ninata Anishinaabe, Ngagudi Chunjishmayan, Giganos Indigenakas, Neashi Winigabing and Don Jaba, Nigigin Dodem. I'm just delighted to be with you and have that wonderful introduction from a good friend. I'm grateful for Greer reaching out and helping to organize this, and it's always good to be with folks from Western. As Michael said, I've enjoyed my association through the years, and you're very close to my territory. My great-great-grandfather entered into a treaty dealing with 1.5 million acres of land in Ontario. If you just go a little bit north to Arthur, Ontario, that would be kind of one corner of where the treaty line went to, and then it would go from Arthur out to Goderich to the west, and then from Arthur north up to Collingwood. So everything north of that area, my great-great-grandfather put his otter totem or signature on the treaty, which invited people to come and share the land in accordance with Anishinaabe law. And what we have learned in that territory is we attempted to create relationships with those that were seeking help and aid and possibility in the part of the world that Western is located on. I'm hoping that I can use the share screen function here. If I'm made the co-host, I can go through a bit of the work that I've been doing in relationship to the title of today's talk, which has to do with practicing law and thinking about ethically practicing law, using the standards for judgment that are given by law societies, but also using the standards of judgment that we can draw from Indigenous peoples as well. So here, the question is located: how Indigenous ethics are foundational to the ethical practice of law. And I recently published a book called Laws, Indigenous Ethics that attempts to look at some of these questions. I'm going to start you with the Ontario Rules of Professional Conduct. And notice the language that's underlined there. A lawyer has a duty to carry on the practice of law and discharge all responsibilities to clients, tribunals, the public, and other members of the profession honorably and with integrity. Now you're going to search far and wide to be able to pin that down. What does it mean to be honorable? What does it mean to act with integrity? What are your responsibilities and how do you carry forward your duties? Well, the Code of Professional Conduct, these rules here, give us some further guidance around the integrity issue, the relationship to clients of competence, quality of service, confidentiality, and conflicts of interest and fees, the practice of law, being professional in the way that we approach our work, our responsibilities to the administration of justice, including the legal system and overall administration of justice, our own conduct towards one another, towards students, employees, and others, including areas such as supervision, sexual harassment, and discrimination. And then this code also talks about the relationship to the law society and other lawyers involving multidisciplinary practices that would consider our responsibilities in that front. So this is the community that we hope to be a part of, or in my case, am a part of, and we act in an ethical fashion is what we're called upon to do. Now here's the British Columbia statement about what is ethical practice. It says a lawyer is a minister of justice, an officer of the courts, a client's advocate, and a member of an ancient, honorable, and learned profession. It is a lawyer's duty, and now you can just see there summarizing what we had in the other context. The lawyer's duty is to promote the interests of the state, to serve the cause of justice, to maintain the authority and dignity of the courts, to be faithful to clients, to be candid and courteous in relations with other lawyers, and then to demonstrate personal integrity. What I want to do with you now over the next 35 minutes or so before asking for questions is outline those bolded points there and relate them to Indigenous law and Aboriginal law, that is Canadian law, dealing with Aboriginal peoples, and consider our practice from these ethical injunctions, these responsibilities, these duties that we have. So promoting the interest of the state, that's right. That's one of our first duties here that the lawyer has. And you can see it here, relationship to the administration of justice, how do we promote that interest of the state? Well, I think it's just imperative on us to know that Canada is a multi-juridical country, that it's formed from the interaction of Indigenous legal traditions alongside the common law and civil law as it's practiced out of Quebec. And understanding the multi-juridical nature of our country will then see that the duties that we have to the state are those duties that would encourage the rule of law as it's embedded in these legal traditions, and how we might harmonize these legal traditions and look for the reconciliation between the different streams that make up our system. In order to do that, to understand Canada as a multi-juridical country, you have to understand, of course, what the common law is, and that's what you're beginning to learn, what the civil law is, and there are people that are charged with that, learning those traditions, and of course, what Indigenous legal traditions might be. The nature and sources of the law that Indigenous peoples carry can be quite broad. They can flow from time beyond time, stories that Indigenous peoples have about their relationship in these lands that talk about the animacy of the earth and the council of different beings in the way that they interact with one another and with the earth. In other words, within the stories that come from time beyond time are guiding trajectories for law that help us see principles, authority, criteria, standards, precedent, resources for reasoning as we have processes and principles for regulating our affairs and resolving our disputes. And some of those are from those kind of sacred ideas. I was teaching US constitutional law for many years at the University of Minnesota and amongst other places. And I came to see another view of sacred law as the US Constitution talks about the framers and what they set up at the time of its drafting and then its ratification. And you cannot have a constitutional right in the US context unless it's traced to either one of the amendments or what the framers did at the time, the stories that they told, the way that they wrote down on paper what their relationships were. In other words, there's something given extra deference in US constitutionalism that can't be changed just by day-to-day processes because of the sacred nature of them, right? So something being sacred doesn't necessarily have to flow from the supernatural. It's deference and respect that we give to ways of constructing law that kind of set things in motion. And Indigenous peoples, through their stories, both secular and sacred, have ideas about how they were set in motion as peoples. And through these stories, you can identify processes and principles to guide behavior. So this notion of promoting the interests of the state would be to recognize that our country is built upon Indigenous lands, that where there are treaties, that country was built in interaction with the Crown. And this has been put to us in the Canadian Supreme Court's formulation of Section 35(1) of the Constitution, saying that Canada's Constitution dealing with Aboriginal peoples is intersocietal, right? It draws on both Indigenous societies and common law and civil law societies. They say that this area of law is sui generis, meaning it's unique or of its own kind. They say the dominant purpose of Section 35(1) is reconciliation, the reconciliation of the pre-existing sovereignty that Indigenous peoples have with the assertion of sovereignty by the Crown. The court calls this area of law a bridge. This is in the Vanderpeet case. It says a morally and politically defensible conception of Aboriginal rights would incorporate both legal perspectives. So this bridge reconciles both Indigenous laws and federal and provincial laws. This is our ethical duty, is to defend the state and not just think we're defending the common law or the civil law or some abstract notion of the Crown, but we're defending the idea of law being formed through participation and mutuality, that democratic ideal where we want to see that people have a say in the creation of those laws. And Section 35(1) of the Constitution, as we think about an Indigenous Constitution, puts that to play. When I did my PhD at Osgoode Hall Law School, I looked at treaties that Indigenous peoples entered into with the Crown that made this point 250 years before the Supreme Court of Canada made this point. These are wampum belts. Wampum are shells that are sewn into hide to make patterns. And these patterns explain what was agreed to between the Crown and First Peoples when the Crown first came to live amongst Indigenous peoples. So here is one kind of agreement that says we are going to live together in the state that will eventually become Canada with this white here, in peace and in friendship and respect. And then there's these two purple rows that are part of that agreement, which are the rivers of life that we all find ourselves on. And on this one river, you have the Crown in its ship of state controlling its affairs. On this other river, you have Indigenous peoples in their canoe controlling their affairs as a nation to nation relationship, right? There's some measured separation. There's some kind of confederation there as Indigenous peoples agree to be in peace, friendship, and respect with the Crown. The Crown agrees to be with Indigenous peoples in peace, friendship, and respect, but allowing the others some autonomy in that journey that we're on down the rivers of life. When the Royal Proclamation was signed in 1763, it said that the Crown was going to reserve the lands that the Indians occupied and that they could not be in Crown possession unless the Indians agreed to those lands being in Crown possession. The 1763 agreement was promulgated on paper, and then Sir William Johnson, the lead official for the Department of Indian Affairs, the Northern Superintendency dealing with Indian Affairs in North America, got 2,000 Indigenous peoples together representing 22, some say 24 different nations, and entered into this agreement here where people linked arms together, right? You can see the 1764 being framed there. And the idea is that they will link arms together and be able to aid one another. So here you've got this in a covenant chain of 24 nations linking arms together across the land. And when the British need help, all they have to do is pull on this hand that's there, and these people will pull together and they will draw the British to shore. Likewise, if someone needs help on this side, they pull the other way and there's help that's brought back and forth. So this linking arms together belt is the idea that when we're settling together in North America, we're going to come to one another's side and we're going to pull back and forth to do the work that's necessary. Now, at first, this link that was there joining the British to the Indigenous peoples was a rope. And then it said we needed something stronger, and so they made it an iron chain. And then eventually said the iron will rust, we need something stronger. And so they said, let's make it a silver covenant chain. And so here's the links of the chain down at the bottom here is represented by silver. And then what happens is that you have to meet regularly to shine that silver covenant chain because it can tarnish, right? And so this notion of treaties here is an ongoing process of continual renewal that's about linking arms together, providing mutual aid and support to one another in peace and friendship and respect. This draws upon what Indigenous peoples did with one another. Here's a dish with one spoon belt where Haudenosaunee and Anishinaabe people had been at war with one another for 50 years. They said, we can't do this anymore. We need peace. And so the peace is recognizing that they're all eating out of a common bowl. Here, this bowl in the middle, this purple object, but they're eating with a spoon, right? They're not eating with a sharp object, with a knife or a fork. They're not threatening one another when they're eating in the territories around Deshkan Zibing, the Chippewa of the Thames area there just in the London part. But look at the white again as being the dominant motif. This is all trying to say that this first point, the lawyer's duty to promote the interests of the state, is to recognize that Canada is a multi-juridical nation, that the Supreme Court of Canada has talked about our intersocietal need for reconciliation, bridging these cultures. A morally and politically defensible conception of our state must incorporate the variety of these legal perspectives. The next point that's in our ethical charge is to serve the cause of justice. And so I wrote this book back in 2002 called Recovering Canada, dealing with the resurgence of Indigenous law. And the cause of justice there is the cause that is again about persuasion. It's trying to pull together the mutual participation that we could join in agreement, or if we're going to disagree, we can find ways to disagree agreeably, that we would create institutions that would process disagreement rather than having to always stand on blockades or go to courts. We would try to articulate standards and principles by which we could act together. This idea is that the rule of law is not might makes right. The rule of law is that we will participate with one another and mutually construct the conditions under which we live and eschew ideas that are built on racism or colonialism. That is, we don't want to build our laws on terra nullius, that the land was empty somehow before Europeans arrived. We don't want to see the doctrine of discovery being the foundation of our law. That doctrine, which says that the Crown has all rights to land and all rights to governance when they landed on these shores, assumes that the people who were here must have been inferior in relationship to their land, laws, in relationship to their governance. We don't want this notion of Canada to be built on might makes right through terra nullius, thinking that people are inferior and can be discovered and don't have the ability to participate in knowing what their land relationships are and what their governance relationships are. We want to eschew this idea of conquest, right? Indigenous peoples were not conquered. We fought alongside the French in the central part of the country there in the 1760s. The French were defeated at the Plains of Abraham, but the Indigenous peoples were not. They continued to fight. They took many of the forts out of the hands of the British in that period. That's why the Royal Proclamation was promulgated, to say we don't want to continue to go to war with you. We want to convince you that we'll be just and reasonable. And this justice and reasonability is to serve the cause of justice. That's it in the actual language of the Royal Proclamation, which again is about the notion that we're not building a country on conquest, discovery, adverse possession, occupation, terra nullius. And so that is the ethical obligation that we have as lawyers to serve the cause of justice. We have a Truth and Reconciliation Commission that made its findings in 2014 and called out to both the Federation of Law Societies of Canada and law schools in Canada to start building this information into the way that we engage in legal education. So here you see the call to ensure that lawyers receive appropriate cultural competency training, which includes the history and legacy of residential schools, the United Nations Declaration on the Rights of Indigenous Peoples, treaties and Aboriginal rights, Indigenous law, like Indigenous people's own law, and Aboriginal Crown relations. This will require skills-based training in intercultural competency, conflict resolution, human rights, and anti-racism. And you see that same call going out to law schools in Canada. Here is the opening day of the new Indigenous Law, Common Law degree at the University of Victoria in 2017, where we have members of our legislature, Melanie Mark here, who's the Minister of Advanced Education, who funded the seats that we could bring in to create this new Indigenous law degree, sitting by our president, my colleague Val Napoleon, elders, in attendance, as well as the students, a part of that new cohort. This law degree teaches Anishinaabe law alongside constitutional law, Cree law alongside criminal law, Gitsan law alongside property or land law, Silcotin law alongside contract law, Hulkaminam law alongside, so we have Hulkaminam law with tort law and contract law with Silcotin law. So students learn trans-systemically, just like you can go to McGill and learn the common law and the civil law together. There's a way of picking up learning Indigenous legal traditions alongside common law legal traditions. And we also have 2 field schools that students would do for 4 months each. So they do 8 months of working in community with those laws before they graduate. Again, this is all in this cause of serving justice, to see that we're not building the country on assumptions that Indigenous peoples don't have reason and that they can't articulate ideas together with one another and with those that have come to live amongst them. And so that's why at UVic we're doing this, but other things are happening in other schools to advance this agenda. The BC Law Society has also responded to the Truth and Reconciliation calls to action by creating an action plan to ensure that the Law Society is inclusive of Indigenous peoples, that there's support for Indigenous peoples coming through the system as students, articling students and lawyers, that there'll be a place for Indigenous involvement to be increased with Law Society government, to improve intercultural competence, to review, evaluate, and report on an action plan. So this action plan has many dimensions to it to ensure the ongoing and long-term relevance of truth and reconciliation. So, this is in our codes of professional conduct to serve the cause of justice. And in the Indigenous setting, here are some of the things that are being done to meet that initiative. Now, the other part is to maintain the authority and dignity of the courts. It's important to recognize that courts have an independence. They're not just creatures of parliament. They're not just creatures of the crown, right? Their legitimacy lies upon being able to answer the questions to people who bring issues before them in a way that addresses them. And of course, it would address what the parliament and legislatures have said about those things. It would address what prior courts have said about those things, but it would also address these points that I've been making. That is, finding that the court's own legitimacy should not be based on just a Western notion of parliamentary or legislative appointment or crown prerogative. Their legitimacy rests on them being able to be persuasive, to talk to us in legal terms. We have a whole field of doctrines under section 35(1) of the Constitution when Indigenous peoples are engaged with the crown, which pick up this idea of the dignity of the courts, having the honor of the crown being insisted upon, that there would be no sharp dealing allowed between the crown and Indigenous peoples. There's a fiduciary duty, duties of utmost loyalty and good faith in particular circumstances that the governments would have to Indigenous peoples. That this idea again of reconciliation and sui generis intersocietal law is a part of the dignity of the courts, the work they do to ensure that they're persuading us, not just going down the path of might makes right. The idea that they put forward in the courts, that they've rejected this idea of conquest. That's in the Haida case. The court said the doctrine of conquest is not a part of Canadian law. They also say in the Silcotin case that terra nullius is not a part of Canadian law and should be rejected. That's part of the dignity of the courts, ensuring that there's no extinguishment of rights without consent after 1982. Here's the Sparrow Standard, not imposing unjustifiably unreasonable limitations on rights, undue hardships on rights, or denying the preferred means of exercising those rights. That is, the Crown has a burden, has a duty. The Crown's sovereignty is checked, it's constrained in this way, not to unreasonably limit or cause undue hardship or deny the preferred means of exercising the right. This idea is minimal impairment of Aboriginal rights, allocating resources to Aboriginal peoples when rights would be infringed, protecting the safety of Aboriginal rights users in whatever the Crown is proposing, ensuring economic and regional fairness when those rights might be infringed, appropriately structuring administrative discretion in relationship to Aboriginal peoples, giving priority to Aboriginal peoples when rights are infringed, providing for participation in resource development, reducing economic barriers, compensation if rights are being taken away, like their forests are being depleted, or minerals are being taken out of the ground, or oil and gas is coming away from them. It could be compensation that's required, consultation with Indigenous peoples before these things happen, accommodation of what they're presenting, dispute resolution mechanisms, mitigation strategies, and not violating individuals' charter rights, right? This is a part of the maintenance of the dignity and authority of the courts, is to uphold these doctrines as well as a part of our ethical practice. We should note that we now have the United Nations Declaration on the Rights of Indigenous Peoples in British Columbia, which is statutory law, right? The province of British Columbia has enacted a process to give force to international law as it deals with Indigenous peoples' rights. And I've tried to write about these things, as you see here, in a couple of books that have recently come out dealing with international trade and Indigenous peoples, and then braiding together domestic law, Indigenous law, and international law in the way that we would think about our opportunity to speak together with one another. Here's that Indigenous Peoples Act in British Columbia to affirm the application of the Declaration to the laws of British Columbia, to contribute to the implementation of the Declaration, and to support the affirmation and development of relationships with Indigenous governing bodies. That this will occur consistent with the Declaration through an action plan with an annual report, that agreements could be formulated that give force to the Declaration. So that's that. Again, the question I'm asking is, how might Indigenous ethics populate our duties ethically as lawyers acting within our system? Here's how partially we can maintain the dignity of the courts, in addition to that point that I'm mentioning about the cause of justice, in addition to that point that I'm mentioning dealing with our duties to uphold the state. We also have a huge duty to be faithful to our clients. And in 2010, I wrote this book called Drawing Out Law, A Spirit's Guide, which tries to give an insight as to what's going on amongst Indigenous peoples as they receive Western law that's coming from the courts and coming from the legislatures. That is, when you counsel with clients, we're not expected as lawyers just to substitute our opinion for their opinion. We're to enhance their ability to act, right? We're to try to facilitate their agency. We're trying to expand the possibilities that they will have to be decision makers by giving them information which will enable them to be fully informed when they have options before them as to what course of action they might pursue. And if we don't have the sense of what Indigenous peoples are thinking, what their agency might be asking for, what they might want to see as options, we are not being faithful to clients by helping to charge them in their roles. Of course, this is a complex area because we're in an adversarial system. So at the same time that some people are acting to be faithful to Indigenous clients, other people are acting to be faithful to Crown clients or corporate clients or public interest bodies. But the point I'm making here is that if we understand that we have to enhance Indigenous agency in this country, that might trigger us to be aware that our role as lawyers is to help facilitate the agency of those that we work with. And sometimes that doesn't occur. Lawyers act like they're hotshots, that they have all the information, and they end up substituting their opinions and squelching the agency of humans that require dignity and freedom. We don't do freedom and dignity a service if we just think that our clients are not able to make informed decision because we know more than they do. I mean, we have to stop acting like that in the profession. And of course, we have much to learn in our society around those points. It is exciting, though, to see the kind of practice that's developing when Indigenous law is involved in taking clients' views into account transsystemically through environmental assessments. There's many environmental assessments that are being crafted that have an Indigenous-run environmental assessment process. So the design of the process would be done in accordance with the council of the community, the elders, the youth. They might involve clans in that activity. They would have then a process that would have a hearing type function where evidence could be received, not only evidence from the Indigenous peoples of the territory, but hearing from the Crown or the corporation, as the case might be, hearing from scientists and weighing and measuring and balancing what the environmental impact might be from the proposed development, then in accordance with Indigenous processes, but also in accordance with Indigenous principles. This is my reserve here. So many of our principles flow from the land that you see they're reflected in the water. And we can have these kind of trans-systemic engagements, like a morally and politically defensible conception of dealing with Aboriginal rights would incorporate both perspectives in the criminal justice system, in agriculture and food sustainability, in species protection, mining, forestry, fisheries, water, housing, city and regional planning, real estate, capacity building, self-determination, habitat restoration, energy, investment and trade, treaties, Aboriginal rights and title, torts, contracts, right? The idea here is in practicing in this place and being faithful to clients, morally and politically defensible conceptions will try to see that law is something we do, not just as lawyers. Law is something that our clients should do as well. It's an activity, it's a verb, right? They're engaged in lawing with you. Or when the idea is finished, they've lawed with you. Or they're co-creators of the law with you. Right? This is the point I'm trying to get across. And even if you never think of Indigenous peoples again, the idea here is that being faithful to our clients is not seeing that the law is just fully the reserve of lawyers, of parliaments, of legislatures, judges, and police. That law is something we should all do. And that's Anishinaabe law. We talk about law as a verb, nakonage, a guided way of decision-making. 70% of our language is verbs. And so it gives us this notion that we're to be conjugating as lawyers, not just categorizing, right? So much of law in the way we sometimes are taught is categorizing. Torts, contracts, property, constitutional law, securities, right? And then we think if we can get the categories right and what the definitions of those categories right, answers will flow. But we don't just conjugate in human activity, categorize in human activity and speech, we also conjugate, right? We put together the tenses of time, and we put together the pronouns in different ways. We have all sorts of markers with verbs that allow for a relationality. And so that's the point I'm making here. Be candid and faithful with other lawyers. And I have to say, a part of my work is to develop this thesis that answers to question depend on the context that you're presented with. It's very difficult to give universal answers to questions that are in all time and place, just put forward in a certain way. The thesis of this book, Freedom and Indigenous Constitutionalism, is trying to say that there are no essential aspects of what an Indigenous community might be. Some might have their language, some might not have their language. Some might have their land base, some might have been kicked off their land base. Some might have certain ceremonies, some might not have those ceremonies. Some might be involved in certain cultural practices, others might not. There's nothing integral to the distinctive culture of Anishinaabe societies. It's something that develops through time organically as people continue to participate in it. Now, there can be things that are very, 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 very important and that look like they're universal in all time and place, things like language and relationship to land and culture, etc. But it's not necessarily so. That is, we have to be careful that we don't just proceed with a priori abstractions or Platonic forms in working through the laws or stereotypes, right? That we have to always take account of the specifics that are before us. And I think being candid and being faithful with other lawyers is to recognize that fact, that our work is work that is contingent. It is congruent. It has this notion of it depends as a part of it. And I also say this about Canadian law too. That the Canadian law, there's nothing that you can point to that is absolutely the cornerstone, that's integral to the distinctive culture of the rule of law. Things like rights and peace, order, and good government are very, 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 very important. But through time and space, people have had laws that have been effective and there's not been rights that have been a part of it. Or they've had laws that have not been built on the Westminster system. It might be a Republican system of government, for instance. I think, in being candid, is to recognize because there's no absolutes, that there's always contingencies, then we have to work on, again, co-constructing those processes and principles where we can persuade one another to agreement rather than force one another to agreement by saying you have to accept this absolute, unalterable point that I make as an Indigenous person or as someone who's representing the Crown or the government. So there we go. We've got these ideas, and this is a notion of serving the cause of justice, again, comes out in this laws, Indigenous ethics work that I put forward. For Indigenous peoples, Anishinaabe peoples, when we put our laws into force, and I'm going to be about maybe 5 more minutes here, these are the laws that find statement in preambles and clauses. Love, truth, honesty, courage, wisdom. We've got honesty there again. That should be respect and humility. And so love, truth, honesty, courage, wisdom, respect, and humility. These ideas are like our life, liberty, security, equality, peace, order, good government, right? They're large general aspirations, but we don't give up on life, liberty, and security or equality just because it's so ambiguous and broad in its articulation. We aim towards it. And so likewise, these are ambiguous, these are broad, but like life, liberty, security, peace, order, good government, equality, these are the things that folks aim for. Here's the preamble to the Anjouanong Constitution, also the Chinaakanagewin Constitution. There's 43 Anishinaabe communities that have this overarching constitution. Here's the preamble, and then those 43 communities will have their own preambles. But you can see here these, I'll just read, Ningo Dwe Wangazit Anishinaabe, one Anishinaabe family. Bain Jagade, Yasan Anishinaabe, a king, give it the Guang, Gadine, Manadu, Wadazuin. Creator placed the Anishinaabe on the earth along with the gift of spirituality. Shkore, Nibi, Aki, Nodin, Gibi, Osdunon, we Nagatawendamang, Mam Pish, Kamingwang. Here on Mother Earth, there were gifts given to the Anishinaabe to look after fire, water, earth, and wind. Bain Jagade, Gi, Mina, Gichwa, Wayne, Dagog, Nishinaabe, Wa, Nag, Donjin, Ninda, Nijwa, Suikinomadnwinan. The Creator also gave the Anishinaabe 7 sacred gifts to guide them. They are Zagidawin, Debwewin, Manain Damawin, Nabuakawin, Taba Dane Dizwin, Kwek Wadazuin, Minwa Akadewin. These are those laws that are in our preambles as well as in our clauses of the Constitution as well. And when you look at these in Anishinaabemowin, you start to understand that these are keyed to the earth. So this idea of Nibwakawin, wisdom, Nit is the personal pronoun, Wa is the idea of light, and Ka is an abundance of. So Nibwakawin is a place where you would receive a lot of light. And so you would look to the natural features of the earth And you would try to reason by way of analogy, how can I be like that site that's receiving a lot of light in that fashion? Or here, Zagidawin. We're the Zagin Anishinaabe. The Zagin is a mouth of a river. It's where the energy flows out to the bay, to Lake Huron in this case. And what happens is all the rivers that flow into the Zagin connect all these nutrients. And because there's so much collection of those nutrients, you get the rich abundance of life at the river mouth, where Southampton is. You get all these microbes and plants and insects and fish and birds and animals living in great abundance because of that delivery of the flow of the river. And then, of course, Anishinaabe and then others later gather there because there's so much to feast on, so much to eat on, so much to sustain in the variety of life that's there with the variety of insects, the variety of plants, the variety of animals, etc. That's Zagidawin. Our word for love is that's Zagin. Our word for love is Zagidawin, right? Same root. If you want to know what love is, Zagit, you look to the mouth of a river and you see the river embodying what we hope humans will do, which is collect energy from all sorts of places, deliver it in defined ways that allow for a rich diversity of life around us so that people can feel sustained, so that people can be together in their broad varieties. So this was also into treaty language, as long as the rivers flow. Right? The idea here is that Indigenous law, this serving the cause of justice and then serving this personal integrity, is a part of our work. My encouragement is that when you're acting in law school, that you try to think how you can be more loving, truthful, honest, courageous, wise, respectful, or humble. That is, what can you do to look to your own traditions that you're working in, both the common law and whatever family or cultural tradition that you come from, but then also see that these laws with Deshkan Zibing are there in London, Ontario, right? As the river flows, there's ways of thinking about what we might ethically do to act with personal integrity. And that's something that starts now in law school. You shouldn't wait till you get to articling or get called to the bar. Are you, in your relations with your peers, being honest? We say kwek being unobstructed with those that are around you. Are you a person that's trying to admit light and not be shady, right? To be transparent rather than blocking things. There's so much to say here with those values, but it's a part of this work. I think I'm going to just stop at this last slide. Our standards of the legal profession. Here's the commentary as part of the British Columbia rules. Integrity is the fundamental quality of any person who seeks to practice as a member of the legal profession. If a client has any doubt about his or her lawyer's trustworthiness, the essential element in the true lawyer-client relationship will be missing. If integrity is lacking, the lawyer's usefulness to the client and reputation within the profession will be destroyed, regardless of how competent the lawyer might be. You might get straight A's, but if you're not acting with trustworthiness, if you're not acting with integrity, you don't have that reputation that people will trust you to extend money towards you in trust funds as you're maybe administering their real estate transaction, or they're not going to put much credence in an undertaking that you would give to be able to produce some information by a certain period, right? These things are the foundation of what we should be doing. Yes, we need parliament and courts and legislatures and police and Section 35 and constitutions, but we need these Indigenous ethics to become laws, Indigenous ethics, not just Indigenous people's ethics, but the law itself won't function if we don't have public confidence, trust, if we don't have this kind of conduct. So I'm going to stop there and hope that there might be some questions. I think I've spoken now for about 45 minutes, and I welcome any comments on any of these things that we've gone through here as we've tried to develop our approach to ethics after this fashion. So I'll stop sharing screen now and say, miigwech bizindwig mit you, ahau, thank you.
Thank you so much. That was a wonderful talk. I just wanted to let everyone know we have the Q&A open, so if they have any questions, they can post them there. And we've got a few already that Sean and I can share with you. So the first question we got is from Julie Lee, and she said, can we have your input and insights on practicing trans systemically in family and child welfare law?
That's a great point. There's a new piece of legislation that was given about maybe 18 months ago that's federal, that deals with child and family services for Indigenous peoples. And it recognizes that Indigenous peoples have an inherent right to take care of their family responsibilities. And in recognizing that inherent right to take care of their family responsibilities, the federal government has created what's called umbrella or enabling legislation to allow that inherent right to be exercised in partnership and be resourced by the federal scheme. And so what's happening right now is First Nations across the country, Métis Inuit communities across the country are using this legislation to take greater responsibility for child placements, adoptions, child protection, those sorts of things. It's a nice model, right? That combines, on the one hand, the pre-existence of Indigenous law, says that survives the assertion of sovereignty, can be used today as the source of authority for child and family services. But under 9124 of the Constitution Act 1867, which says that the federal government has the ability to deal with Indians and lands reserved for Indians, it kind of harmonizes that. What's happening right now, though, is that there's a challenge, a reference being taken by Quebec. Quebec says that this is ultra vires, the federal government, to step into the sphere of dealing with child and family services, because that is more property and civil rights in the province. So the provincial government of Quebec is saying that it's unconstitutional to have this kind of structural arrangement where the Indigenous body, authority might occupy the field and the provincial government would have less of a place there. Now, there is provision in that legislation for harmonizing with the provincial schemes. It's not like the province has no role to play at all. In fact, it's quite strong that the province would play a role there, but they might not have the final word, right? The paramountcy might not be with the provincial government in that instance. And so that's what the debate and disputes about. And so there's one way of answering the question, which is to think about it constitutionally. Another way of answering the question is there are opportunities for you to get involved with friendship centers and Indigenous communities to support young children and families in the work that they're trying to do, not just through placements and adoptions, but they're always looking for big brothers and big sisters and looking for people to help in, and we're not in COVID times, but that's such an amazing part of what can be done as you start to form interpersonal relationships when you're drawn in then to Anishinaabe law customarily by being with a little child that might have some need to be introduced to the kind of skills that you have in the world. It's a beautiful thing, and so I'd welcome you to think about that as well. And in the process, you'd start to understand Indigenous law too.
Great, thank you. Sean, did you want to take the next question?
Yes, thanks, Greer. And thank you, Professor Barrows, for being here today. Our next question comes from Tyler Matthews. And he asks, as a measure of reconciliation, how do you think the creation of the Specific Claims Tribunal has made justice for past wrongs more accessible for Indigenous people? And in your opinion, has that been successful?
Okay, that's a great question. Let me just explain what the Specific Claims Commission is for those that might not be aware, but there's an administrative tribunal that's given some independence to be able to make findings of fact and then give remedies if the Crown has breached an obligation to Indigenous peoples. Often they're treaty violations. And so this tribunal hears those claims on an independent basis, gathers those facts, and then awards remedies when they're warranted. I think that's brilliant because what it does is it takes the issue out of the courts. It also starts to involve some Indigenous process and principle along the way, although right now that's the smallest part. And so if I had future recommendations for what the specific Claims Commission might do, is to adopt more Indigenous civil procedure. Maybe a feast might be a part of the way the parties gather. It could be a fact-finding function where you involve elders, perhaps, along the way. I know some of that is happening. I really appreciate what's going on, and then there's further room for refinement. So yeah, I think it's a great thing that's going on there.
Okay, great. I have a question submitted by Nikki that kind of goes off what you just talked about. So Nikki says, how do you envision the ideal reconciliation of Indigenous law and Canadian law, specifically considering the multitude of tribes? Would there be a singular court system that follows Indigenous law, or individual courts following each tribe's tradition? And then I guess just going off that question, I guess, what do you think of the feasibility of a court system similar to the tribal court system in the States being implemented here?
Yeah, so I taught at University of Minnesota, like I said, and I was there for 5 years, and I have this huge tribal law casebook. And these cases come from Cherokee and Blackfoot and Salish and Haudenosaunee. And what's inspiring about it is that they have their own way of functioning that is consistent with their own cultural context, with their legal tradition. So those tribal courts will often, first of all, reference their constitution when a decision comes before them. And sometimes that constitution is unwritten, like in the case of Great Britain, right? The Navajo Constitution, for instance, is unwritten. And so a lot of Navajo jurisprudence tries to understand that unwritten tradition. Other tribes, as they're called in the United States, have a written constitution. And so the court would first look to that written constitution to try to figure out how they might answer a question. And you'll see things in the constitution like love and honesty and truth and wisdom. And the court has to give meaning to that in a, say, an election decision, or a property dispute, or a contract question, or a slip and fall issue, right? They have to think about what would love or wisdom or truth require in that. So constitutionally, they've got sources to go on. And then the communities pass legislation. And then under that legislation, you can have regulations. And then you've got the common law, as it were, of the Salish or Cherokee or Haudenosaunee that itself can come to bear. Like the duties of care that we found in the tort context that grew from the common law, you have these kind of duties that would be there in a common law situation. And then you have the decision of the past courts within the tribal structure, so that, you know, once you've gone down that list, you look to, well, what have other decisions said about that prior to us coming to this decision today? And if there's a decision that already governs, then we'll apply that. If it's not quite the same, and then we'll distinguish that, right? That's very familiar to us, but they're just using a different legal tradition to get there. What was interesting to me is that this courts will then cite other tribal courts more than they will cite federal courts and state courts. Because they're sovereign as a nation, they find it more persuasive to look at what other Indigenous peoples might be doing in answering similar questions than they do federal and state courts. Then there's a process of harmonization. So when a tribal court promulgates or gives a decision, it can be accepted either through a full faith and credit or comity type of relationship that you sometimes get in conflicts of laws. Sometimes states have entered into recognition agreements with tribal courts that say, in these areas from these courts, we will recognize laws that flow from these notions. And so, you know, it's just set out by agreement. Sometimes the courts have to make sense of what the agreements might be in absence of formal declaration. There's also annual meetings of justices and a state or federal court, as the case might be. It would be wonderful one day to see some kind of structure happen in Canada. It doesn't have to be adversarial. You could have peacemaking courts, you could have feast courts, you could have circle courts, you could have, there's so many ways to put dispute resolution together. It doesn't have to be like I've described in the formal setting, but the process could be there that allows for this. And then, at the Supreme Court of Canada, we could have some judges that have knowledge of Indigenous legal traditions when cases might come up in that way. We could think of maybe creating a constitutional court that would be separate from the Supreme Court of Canada, where Indigenous issues might be almost finally determined there. We might think about harmonization legislation. So whenever there's a gap or a conflict between between the common law and the civil law, there's a whole piece of legislation that's designed to have you work through those conflicts and how to best resolve them. And then there's a whole ministry or bureaucracy that's charged with giving effect to that harmonization. So not everyone in Canada has to know every legal tradition that Indigenous peoples have. You don't have to know all about the common law and the civil law, but some people do. And if that cadre or cohort knows about that harmonization process, then we can go on with our business as usual, right? Because most civil lawyers in Quebec will never think about the common law, and most common law lawyers will never think about the civil law, and we can get along and do what we have to do. But some people have to think about that. And so it's adding to that with Indigenous law, some people have to make that a part of their role. And that doesn't displace and cause the rest of us to have to just reimagine our entire world. We can do the stuff that the Truth and Reconciliation Commission demanded without having chaos. So those are some of the ways, and there's probably many more ways. Treaties we could do this through, etc. But I'll stop there.
Thank you. I will now ask another question from the Q&A. This one is from Allison. How does one practice in a way that makes Indigenous ethics overt and explicitly present in one's work, rather than as a sort of implicit or informing principle?
Yeah, so that'll depend, right? That's one of my grand pieces of advice. Don't proceed on the abstract. Find what the context requires. But those contexts could require you writing a legal opinion that doesn't just cite what comes from the Ontario Court of Appeal, the Supreme Court of Canada, but it might require citing what the Anishinaabe Constitution says the legal standard is. And there are all these tribal courts that are Anishinaabe just south of the border, Michigan, Wisconsin, Minnesota. They might find their way, just by way of analogy, not to bind the court in that instance, but as persuasive, perhaps, if they're Indigenous folks there. People might, these territory acknowledgements, I'm on the Lekwungen territory right now. Wasanich is also here. It's Esquimalt and Songhees, recognizing where you're relating your work from. And I'm grateful for all of that support I've received as I've been learning in these territories out here on Vancouver Island. That's something that can be done. Some people, when they get called to the bar, they'll swear on an eagle feather, or they'll recognize the importance of other ethical traditions that to pull that forward explicitly. You could serve on your law school's Truth and Reconciliation Committee, or you could serve on the CBA or in the Indigenous Bar Association, bring these things to light. Again, all these different areas of law have their own application where Indigenous law might be there. So it's the work of co-constructing it if it's not there, and if it's there, it's identifying it and getting involved with it.
Great, thank you. And we have another question in the chat. This time it's from, I hope I pronounced this correctly, but Layeli Derink. And she asks, what potential role do you see for individual constitutions in Anishinaabe communities in Ontario who opt not to vote on the self-governance agreement negotiated through the Anishinaabe Nation, or for those communities who vote nay?
This is a great point, and it gets to the issue I was just briefly identifying, that the Anishinaabe Nation is creating somewhat of a federalism structure in Ontario, where there is one level of authority which is across the nations, and then there's another level of authority that's found within the Anishinaabe nations. What's different about this is that across the board authority is the junior partner, as it were. The paramountcy would be there in favor of the local communities. And there are other Anishinaabe communities that have done that. In Minnesota, There's the Minnesota Chippewa tribe. They operate through a federal structure, and they've done so since the New Deal, since the 1930s. And so what's happening in Ontario right now is communities are voting on that overarching, or that, I shouldn't say overarching, because it's not really over, that nationwide constitution. And then they're also voting on their individuated constitutions within their groups. What happens if someone just picks one level and not the other level? So they maybe just vote for the national and not the local, or just the local and not the national. A part of putting together the future of the Anishinaabe Nation is to recognize the unity amidst diversity, to recognize that even if we don't vote to participate together, we're still going to have to create structures that will deal with the fact that in an unwritten tradition, we are all related. When I introduced myself, I said, Bujun Indiniwe Maganidok, which was hello, all my relations. And there are people from the Otter clan across all these nations, or the Bear clan or the Crane clan, even if they don't ascribe to the written constitutions of these other areas, we still have that other constitution that's there. And part of our work in the future is to figure out the relationship of all those constituent parts. That might feel like, wow, that's too big, but that's just the work of law, right? In the Canadian context, we have municipalities and provincial governments and federal governments, and then corporations that are natural persons and human beings that are persons. And we just have so many things going on, and we don't throw up our hands and abandon it and say, this is too complicated. There's just too many players here. We say, no, we need to keep working to bring these parties together in understandable ways. And I think the Anishinaabe have that same opportunity, which is also a challenge, but it's there, and I think that's what's going to happen, and that is what is happening.
Thank you. I have another question here from a Google Doc that we had up earlier. This one is from Dylan, and he was wondering what are some of the biggest challenges influencing the adoption of Indigenous legal ethics?
Yeah, I think some of the biggest challenges is that people don't know about them. And so there's an educational challenge first and foremost. Like, tell me is kind of the question, what do you mean? What are these things? And so there's that's there. Once you had some information, people sometimes like to think about the rule of law as being one thing, as opposed to seeing the rule of law as about being many things. And so if you think about the rule of law as being one thing, you might think this isn't irrelevant, or this is irrelevant to me. It's not a part of what I should be considering. So there's those kinds of sort of almost ideological challenges. But when you think about the rule of law, again, the federal government passes the criminal code, but it's ministered by the provinces, right? We're used to having the rule of law be many things. And it's not like we haven't heard about love or honesty or truth or wisdom in the broader society as well. It's just trying to engage in a conversation that would bring that forward and give that more emphasis in the way that we proceed as well. There are some people that have told me they don't believe there's any such thing as Indigenous law. Other people have told me that Indigenous law is inferior, it's primitive, it comes from savage times. I mean, I don't agree for that for one moment, but I've been teaching 28 years. I've heard that. Other people say it's too complicated. There's many reasons why we might not want to go there. But I think we need to co-construct this. And I'm not saying that it should be everything for one moment. My mother, she taught me how to cook when I was a kid. I used to love sitting on the counter, watching her put all these ingredients together, right? The sugar and the flour. And then she'd take this little pinch of yeast, and she'd say, if we put that in, everything else will rise when it's ready to go. And that's kind of my view of this field, right? There's all these other ingredients that people have to keep doing their work in their own ways, but we need that pinch. That yeast needs to go in, and it would potentially cause everything else to rise by being in relationship with it, by being in conversation with it. And so that's my view. I don't think it's an unreasonable view. It's what the Supreme Court of Canada is asking us to do. It's what our law societies and law schools are picking up as a result of the calls to action.
All right, thank you. We have another question now from that Google Doc that is kind of going off what we talked about earlier about the tribal courts and making separate courts for Indigenous law. So we have a question from Kristen Chung, and she asks, to increase the recognition and application of Indigenous ethics in law, should we pursue a mandate that prioritizes Indigenous representation among individuals within the judiciary, or rather dedicated Indigenous law courts? In your view, what are the key differences in outcomes and implications that these two approaches entail?
Yeah, so I do think we should do both. And we might not always have the resources to do both. And so choices would have to be made. And my choice would be to revitalize Indigenous law, get those normative systems in places where there's credibility, there's rigor, there's transparency, et cetera. And as that law is revitalized, as it's resurgent, then ideas will start to come out of that that could be picked up when they're appropriate, they're potentially helpful. There's reasons behind them, right? There's, you're not just taking someone's word for it. There's something that's been thought through as to why, in this context, that Indigenous law might be helpful, because you've got the community's view on that from their legal institution. And as that resurgence, revitalization starts to happen, and others figure out how that might relate to their practice, almost by a process of osmosis or transmission, like that's what the law is, right? It's very incremental in our common law setting, and we would grow it that way. I don't want to wait forever for that. I'd love to see the UNDRIP legislation, which puts this into place, or the kind of enabling legislation in the child and family services sphere that we saw. Perhaps we could do that in the dispute resolution sphere, or in a particular area like the environment, where you would gain the insight of those laws coming forward from Indigenous peoples using their regulatory and dispute resolution functions. And as that happens, then it's just almost more natural to populate the wider system with ideas in other tribunals or provincial or superior courts.
Thank you. We have another question from the Q&A. This one's from Arian. If we can form distinct legal jurisdictions for Indigenous and non-Indigenous Canadians, would non-Indigenous individuals be able to make use of these Indigenous legal systems as well?
So that depends, but my hope would be absolutely yes. If people want to participate with Indigenous peoples and they're doing so in accordance with their rule of law, I think it would strengthen Indigenous law at that point to see that it's not based on race, it's based on, this is a political community with a normative tradition that can be participated in by others. And so then there's a multitude of ways that you can think about that unfolding. Representation on some of the dispute resolution functions, if they're going to apply Indigenous law. In fact, some of the tribal courts that do this work are people from law firms in Minneapolis and Denver and Berkeley, California. Some of them are Indigenous, some of them are not Indigenous, and you have to learn the tradition to be able to be a tribal court judge in that setting. So that's there. I also think it's the case that, I think I'll just leave it there. The point is that, yes, I would love to see if someone married into an Anishinaabe community, that the community would create naturalized citizenship provisions. That here's the pathway to becoming Anishinaabe, politically speaking. I'm not talking about ethnically, I'm not talking about racially, I'm talking about participating in that place, because 50% of marriages that Indigenous peoples enter into are with non-Indigenous peoples. That means over a couple of generations, we're going to be disenfranchising all of our kids and the folks that they're forming relationships with, unless we have something that thinks about sort of naturalized citizenship. The Fleet Show have done this in the Northwest Territories. You could grow up in Germany, you could live in that territory for a certain number of years and take a citizenship oath to abide by those Tlicho laws, and you can become Tlicho, even though your heritage and your citizenship might have come initially from another place. I would love to see that. I know there are complications and challenges with that. The idea of cultural appropriation is big on my mind. I'm not suggesting cultural appropriation for a moment. I'm talking about political organization in accordance with a community set of standards that would implement a normative system.
Right, great, thank you. That makes a lot of sense, and that was a really interesting question. I think we have time for maybe one more question. So we have another one in the Q&A from Nicholas Murphy. He says, broad question from a non-lawyer. Historically, Indigenous nations and the Crown seem to have understood treaties differently, i.e. as dynamic relationships creating agreements versus transactional legal documents aimed at creating certainty with respect to rights and power. I wonder if you could comment on whether these two understandings have been reconciled, and if not, how they can be.
Great question. Both of those perspectives are there, both the transactional and the relational. Courts have chosen different of those points of view through time. I do think that the weight of opinion is going towards seeing treaties as relational and not just transactional. The court says in many of its cases that there's an honor of the Crown that needs to be always in place in dealing with Indigenous peoples and the interpretation of those treaties. And in a case called the Mikisew Cree case, the treaty just started the process for reconciliation, by no means finished it. And the court said it's an ongoing process, a relational process. And I would love to see that insight be facilitated, revitalized, resurgent, because that is just better for us as a country again. It's not building us on a might makes right foundation. It's building us on a relational foundation. That is that we have ongoing through time obligations and responsibilities to one another and to the natural world. And yes, we can do transactions along the way, but the transactions have to be underneath the relational, right? Otherwise, we get non-ethical behavior. If you act as if you're without relations, you act in ways that disconnect you from this deeper weave that I'm trying to say underlies all of our laws, which should be about, I have love in the world. And that love isn't just for my family. I have this feeling, like I talked about with the river, for the people that I teach and for the people that I interact with. That's really hard to say in today's world, right? And even if you said it, it might just not be credible. So we need to act it. And I just want to see more of that relational side of the possibilities come forward, because ultimately, for me, that's more democratic. That's more consistent with what our aspirations are as Canadians, is to not be about might makes right, but to be participatory and mutually engaging with one another. So thanks for that question.
Well, thank you, Professor Barrows. On behalf of the entire Western Law community, we would like to thank you for your attendance and your speaking here today. It's been a great honor to have you here and as our inaugural speaker for the Distinguished Speakers lecture series, and that's been fantastic.
Thanks for that invitation. I've really enjoyed it.
Yeah.
Thanks so much.
Thank you, and thank you to everyone who attended today as a participant and took part and asked questions.
Take care. Bye.